the event you become subject to a bankruptcy order, it is not inevitable that you will lose your property. However, the property will form part of the bankruptcy estate, or at least your interest in that property, if there is any equity in the property. Under the current insolvency legislation, it is for the trustee of your bankruptcy estate to deal with the property within a 3-year period from the date of the bankruptcy order. It will be possible for a third party, usually your spouse, to make an offer to the trustee to account for the value of the interest in the property, and properties are often dealt with in this way by negotiation. Given that the trustee has 3 years to deal with your interest in any property, it may be that the trustee, whether that's the official receiver or another insolvency practitioner, will defer that decision until late in the 3rd year of your bankruptcy in order to assess whether the equity in the property has increased as a result of property increases. He may therefore only be willing to do a deal with you with regard to your interest in the property early in the bankruptcy if the offer received from the third party for your interest potentially reflects any increase in the value of the property over the next 3 years. Should you wish to deal with your affairs by means of an individual voluntary arrangement, you will be in a position to potentially propose that your interest in the property be excluded from the voluntary arrangement. However, this will require the consent of the creditors if it is to be binding, and is usually only going to get their agreement if there is very little equity in the property or very little prospect of there being equity in the property over the proposed duration of the voluntary arrangement. If you are a tenant or have a lease and are dealing with a landlord, in the event of you becoming subject to bankruptcy proceedings, if the landlord is a creditor, which is highly likely because you are party to an ongoing lease with him, which is an ongoing and future liability, then there's a legal duty upon the trustee of your bankruptcy estate to notify your landlord of the bankruptcy proceedings. Your landlord is likely to be a creditor not only for rent, but also for what are known as dilapidations. In other words, your duty under the terms of the lease to meet the costs of returning the condition of the property to what it would have been at the beginning of your occupation.